Okay, chapter 7, ownership of real estate. In this chapter, we're going to describe different forms of ownership. We're going to explain the differences between condos, co-ops, and timeshares and learn what they are. And we're going to start off with tenancy and severalty, which even though it sounds like more than one, severalty, it actually, the root word is sever. Your interests are severed from all others. So tenancy and severalty means sole ownership by one person or entity. I know it sounds severalty, sounds like several, but it's actually based on the root word sever. Your interests are severed by all others, one owner, one person or entity. An entity is an artificial person for taxation purposes. So the owner is free to devise the property to anyone, uh, like in a will, or to their heirs or devisees. So I'll let you guys get those highlights down. Hope you all had a good weekend.
Same to you.
Thank you. Thank you. Everybody good? All right.
Yes, thank you.
And we saw this one before, but now we're in chapter 7, so we could finally see it in the chapter where it belongs. So you could write this now above where it says giving, write OR. First, do the highlight. First, highlight the area where you're going to write this so it don't smudge, and then right above it. OR and EE. OR above giving, EE above receiving to remember legal terminology. As long as you know what the root words mean, the word, when you add OR to the end of it, that's the person who's giving whatever the root word or product is. Words that end in EE is the one that's receiving it. Like devise is to leave property to someone in a will. So the devisor is the one who's leaving that property in the will, and the devisee is the one that's receiving it, so on and so forth down the road here. But remember, the one mortgage is the one that people usually have trouble remembering because a mortgage itself is not a loan. You could have a mortgage loan, but a mortgage itself is a promise to pay. And banks don't make promises, they make loans. So mortgage, the mortgagor is the borrower, right? So they're the one that is giving their promise to pay to the bank. In return, the lender, the bank, they give the loan. Uh, Now, what is that promise that's being made by the borrower? Well, they're saying, hey, I promise to pay you back according to the terms that we agreed upon in the note, the document called the note. And if I fail to pay you back according to those terms, you could foreclose on me to take that property back, sell it at auction, and then use the proceeds to pay off the debt. That's what that promise is saying. Okay, let's move on to the next one. All right. So this is just another slide for that same stuff, but I just get into the ones that we really do, that we study or know. And that's devise, grant, legacy, lease, and mortgage. Yeah. And then I give a definition down here of what that mortgage is, like I just said to you. Uh, the book doesn't explain it like that, but I do right down here. And then what is a lease? Well, I also give you the definition of a lease. It's a contract where an owner of land intentionally conveys most of their rights and interest as defined in the lease document, to another person, the tenant, for a limited period of time as defined in the lease. So a lease is an intangible asset that's also personal property. Um, but the owner's conveying their property, but they're also passing on most of their rights to a tenant. And so, therefore, the lessor is the one that gives the lease, and the lessee is the one that receives it. That's the tenant. Mortgage companies often misuse the word mortgage. Lenders often misuse the word mortgage. So here's a commercial where you could see that too. But just remember, it is who is the mortgagor?
The one giving the mortgage.
The borrower.
Oh,
You got to
that's what I
sing
meant.
back to me. Come on. The mortgagor is the borrower. They may not give you a question like that on exam, but they may have a long-winded question that has the words mortgagor, mortgagee in it. You need to be able to figure out who the players are like that. That's why I say a lot of this exam is about terminology. It's not maybe that the question they're going to ask you a question on who is the mortgagor, but they're going to have a lot of these terms in the questions. And if you don't understand them, you're not going to understand what the question's asking of you. You got to understand who the players are. Who's the mortgagor? Who's the mortgagee? The mortgagor is the borrower. The mortgagee is the lender. You see how easy it comes like that when you don't got to think about it? You just sing it. So, look, even banks misuse these terms. Look at this commercial.
You can't hear it.
Oh, okay. Hold on a second. I got to optimize those
Mhm.
audios there. That's what happened. Okay.
Looking sharp, Len. Who's the lucky lady?
I'm going to the bank to discuss a mortgage.
See, you need a loan, you put on a suit, you go crawling to the bank. This is how I dress to get a mortgage.
Well, first,
Looking.
well, first of all, you don't get a mortgage; you give a mortgage if you're the borrower, right? So they misuse the word right there. Oh, and then we're starting off at the same spot again. Hold on a second.
Lucky lady.
I'm going to the bank to discuss a mortgage.
See, you need a loan, you put on a suit, you go crawling to the bank. This is how I dress to get a mortgage. I just go to Lending Tree. I calculate how much home I can afford. I get multiple offers to compare side by side. And the best part is, the banks come crawling to me.
Everything you need to get a better mortgage. Clothing optional. Lending Tree. When banks compete, you win.
Okay.
Awkward.
Awkward. Okay, I love that commercial. Anyway, they got the even the banks, even the lenders, you could see in this commercial, they misuse the terminology too. But we need to get it right because on exams, they're going to judge us. Whereas somebody calls us and they misuse the terms, we're not going to be there sitting there correcting them, their vocabulary. But, ours will be on exam. So get it right. All right, so here's the forms of ownership. We have tenancy and severalty, where it comes from the root word sever. So your interests are severed from all others. So tenancy and severalty is ownership by one person or entity, like a corporation or a company can own real estate, but if it's only one that does, it's tenancy and severalty. We're going to go over tenancy by the entirety, which is ownership by married couples. We're going to go over tenancy in common, which is the default form of ownership with more than one owner, not married to each other. And we're going to go over joint tenancy. This is a special type of tenancy ownership where you have more than one owner, not married to each other. And there are certain conditions that need to be met in order to have a joint tenancy. And you have to specify you wish to take ownership in this form. Otherwise, the default form of ownership is tenancy in common. So we're going to go over those in the coming slides. And even though we're going to go over them and you're going to learn them very well, you got to see how they phrase it on the exam questions. Real estate licensees should never advise someone as to what form of ownership to take. So I'm going to teach you about these and you're going to understand, you'll know probably which is the best form of ownership to take or be able to spot the forms of ownership, but just don't advise anyone on what form of ownership they should take because that's legal advice and we're not attorneys. So we don't give legal advice, right? So just recognize that. If they ask you on exam, which form of ownership would this be in this scenario, go ahead, answer away. But if they ask you, how would you advise they take, which form of ownership would they take? Trick question, even though there's an answer there that you know is perfect for the answer, do not answer it. Select none of the above because that's a trick question because that's legal advice and we don't give legal advice. Okay. So let's highlight the tenancy in common notes here. It's the default form of ownership when you have more than two or more people that own real estate together. Okay. And they're not married. So in a tenancy in common, each owner has an undivided interest in the entire property. So you can't tell which portion is mine, which portion is yours physically. It's an undivided interest. If I'm 25% owner, I'm 25% owner of the entire property. It's not like that corner over there is mine, you know? So it's impossible to physically distinguish which part of the real estate is yours because you're 25% owner of the entire property. So although tenancy in common does not require equal ownership shares by all of the owners, it is impossible to distinguish physically which specific portion is yours. Tenants in common do not necessarily have equal shares of ownership. They don't have to. In a tenancy in common, each owner can sell, convey, or mortgage or transfer that interest without the other owner's consent. You could sell your own ownership interest, but that may be a little bit difficult to do. Finding someone to buy a partial ownership interest in a property, become partner with a bunch of strangers, you know. And now, upon the death of the tenant in common, that interest passes to their heirs or devisees, those named in the will. If a tenant in common wants to dissolve the co-ownership, but the other parties do not voluntarily agree to a determination, they could file a suit in court called a partition. A partition proceeding, the judge will see if they could physically partition the property, and if that is not possible, then they will order the property sold, and each of the owners will get their proportionate shares of the profit from the sale according to their ownership interest. In New Jersey, a conveyance of two or more people not married to each other by default creates that tenancy in common, unless you specify a different form of ownership in the deed. And we'll get to that in a minute. The tenant's shares would be equal unless otherwise described. Okay, so if you have a tenancy in common and you and I buy the property together, but you put up 75% of the cash and I only put up 25% of the cash. If we do not specify in the deed that you're 75% owner and I'm 25% owner, we're 50-50. That's what that's saying. You have to specify it. Otherwise, it'll assume equal ownership. Okay, you guys good here with the highlights?
Yep.
All right. So here's my slide all about tenancy in common, those details and stuff that you've been highlighting, with a couple of other notes I added in. You know, it's the default form of ownership, two or more owners, people or entities not married to each other, automatically creates a tenancy in common, a TIC. That's the commercial real estate world. They love their acronyms. They call them TICs, tenancy in common, unless otherwise specified in the deed that the ownership's to be taken in another form. Corporation can be a partner with a partial ownership interest, and it doesn't need to be equal. So they can have unequal shares, one 25% owner, another 75%. And if you don't state it specifically in the deed, you're 50-50.
Got it.
This is the same stuff that they mention in the book, but they don't word it this way, you know?
Yeah.
The owners can devise their interest, leave it by will to anyone upon their death, and they could sell their interest without the consent of the other co-owners. However, I got a note here for you. Licensees must use caution when selling partial ownership shares and not the entire property. This could be classified as a security. And to sell securities, you need to have special licensing. Series 3, Series 5, Series 7 licenses. I'm not sure which license is required specifically for this. I don't deal in securities. So, but they would also need to have a real estate license involved because this security is dealing with real estate. So I've read an article that a commercial agent sent me one time. I must have read it 5 times, And there must be some kind of real nuance in there because it was written by someone talking about the IRS and what they classify as a security and what they don't. And it's very hard to distinguish. So, yeah, I'd say get somebody involved in there that has that securities license. And if you're selling someone's partial ownership interest, okay. Owners have an undivided interest in the entire property where they cannot physically distinguish which part belongs to who. And unless you buy out your partner's interest, you'll never own it in severalty. When one co-owner wants to sell and the others don't, you could ask them to buy you out. You could try to find a buyer and sell your interest, which may be difficult to do. Or you can partition a property. You could take them to court, force them to sell the property if they cannot be physically divided. And then because of that, they're being forced to sell. It is a partition is a form of involuntary alienation. What does that mean? An involuntary transfer of property. Alienation is a transfer of property. Okay, so you guys want to snap a picture of this slide?
Got it.
There you go. It's pretty much everything you need to know about tenancy in common. Now, if you got two or more owners not married to each other, creates a tenancy in common in the deed. Unless you specify otherwise. What would you specify otherwise? You'd specify joint tenancy. So let's write next to that, next to joint tenancy there. It says two or more people. We're highlighting two or more people. Now, where it says people, I drew an arrow up to the note up top that says not entities. People, not entities. Corporation can never be a joint tenant. So corporations can never own real estate as a joint tenant. Why? Well, it's ownership by two or more people that can choose to own property as joint tenants. The main feature of joint tenancy is that it carries with it the right of survivorship. That means that if one joint tenant dies, the surviving co-owner or owners will automatically split the shares of the owner who had died. So they cannot leave it in a will to their heirs. When you die, the co-owners get it. This is why a corporation can never be a joint tenant. Corporations don't die, people do. You know, corporations, they could get shut down, you know, but they don't die. CEO dies, they just replace that person with someone else, right?
Yep.
So what is the sole benefit of joint tenancy? The right of survivorship. You'll need to know that for exams. Let me know when you have the notes and the highlights there.
All set.
Got it.
So joint tenancy, eventually as all the co-owners die, the ownership is divided equally among the surviving co-owners, which will eventually leave one man standing at the end of the day, the last man standing, right? So to speak. So as the co-owners die off, the survivors will automatically equally split the shares of the owner who had died. So in order to create a joint tenancy, you have to specify it's the form of ownership you wish to take. So in the book here, we just highlighted to create a joint tenancy in New Jersey, language in the deed must expressly state that titles to be taken in that form of ownership. Okay. And in order to create a joint tenancy, you have to have 4 unities in common. TTIP is the acronym to try to remember it. That's the unity of time, title, interest, and possession. You have to have these 4 things in common to create a joint tenancy. If you do not have these 4 items in common, it is not a joint tenancy. So highlight 4 unities are required to create a joint tenancy, and right next to that, 4 unities, TTIP, time, title, interest, and possession. This version of the book, they put it in a different back scrambled up order here. So just write it the way I got it. It's easiest to remember. TTIP, time, title, interest, and possession.
I think it'd be helpful to hear an example of that. Like, I'm wrapping my mind around like having these interests in common: time,
Well,
title.
I'm going to explain what each one of them are. I just want you for right now, first, just write
Okay,
down the notes and do the highlights,
got it.
and then I'll
Okay,
go over the details with you. I won't leave you wondering. Okay.
okay. Thank you.
Just let me know when everybody's got that. Four unities: TTIP, time, title, interest, and possession, and the highlights down.
Got it. Got it.
Okay. All right. So the unity of time. Let's go down here. The unity of time. Time. All joint tenants must acquire their interest at the same time when they buy the property. Right? They have to buy it together. The unity of title. All joint tenants must acquire their interest using the same deed when they purchase it. The unity of interest. All joint tenants hold equal ownership interest. You can't have somebody that's 25% owner and someone else that's 75% owner, or two owners with 25% ownership and one with 50% ownership. They have to have the unity of ownership interest. That's all that means. And then the unity of possession, where whatever your interest is, 25%, 50%, whatever your interest shares are, you cannot physically distinguish on the property which side of the property is mine, which side of the property is yours. You're not spray painting a line down the center of the property, say that's my side, that's your side. I have 50% ownership in the entire property, not that this side's mine and that side's yours. That's what they mean by unity of possession. Okay. So I even wrote that definition down here at the bottom of this slide here. Means you cannot physically distinguish which part of the property is owned by an individual. If you are a 50% owner, you own 50% of the entire property. You cannot physically distinguish which part of it is yours versus your co-owners. Okay. Those examples clear it up a little bit. The TTIP, time, title, interest, and possession. Yeah, it's not that difficult. Don't read too much into it. Yeah, it's easy to try to overanalyze these things. It's really that's all it is.
Yep,
Okay?
got it. Thank you.
You're welcome. Okay, so why would you want a joint tenancy? Why would you want to create a joint tenancy?
Maybe you didn't have enough to purchase the building on your own.
You're making it more difficult. You're looking for actual scenarios. I don't give you advice on how to take the ownership, remember? But why would you want to create a joint tenancy? It's because you wanted the right of survivorship for some reason. That's the answer I was looking for. Okay. Not for practical scenarios or anything like that. Just why would you want to create a joint tenancy? Because you wanted this right of survivorship, because that's the only benefit of having a joint tenancy, right?
Yeah.
So because you wanted the right of survivorship is the answer there. If you wanted something like a scenario, an example, talk to an attorney. Because that's the best way of avoiding liability, right? We don't give that advice because that's legal advice. And what are the four unities required to create a joint tenancy? TTIP?
TTIP.
Time, title,
interest, and possession.
Interest and possession. There you go. So I guess you could call it the poor man's will. It doesn't need to go through probate. When somebody dies, the co-owners automatically equally split the shares of the owner who died. So two or more owners, usually not married to each other. A corporation can never be a joint tenant because of its perpetual life existence. A corporation will never die until it's formally dissolved. Now, to create a joint tenancy, you have to specify you wish to create a joint tenancy at the time that the ownership is taken. Otherwise, the default form of ownership, two or more people not married to each other, creates a tenancy in common. And the only benefit to having a joint tenancy is the right of survivorship. So if one of the co-owners dies, the others automatically equally split the shares of the owner who died. So therefore, if you own as a joint tenant, can you leave your ownership in a will to your heirs? No.
Say one more, say the question again.
If you have a joint tenancy, can you leave your ownership shares in a will to your
No.
heirs?
No.
No, because when you die, the survivors automatically equally split the shares, the surviving co-owners. Now, all owners must have equal ownership shares for it to be a joint tenancy. You can't have 50% owner and 25% owners. Everybody has to be have equal ownership shares. 2 people, 50-50. 3 people, 33 and a third. 4 people, a quarter. And so on and so forth. So all owners hold an undivided interest in the entire property, where you cannot physically distinguish which part belongs to who. Each owner can sell their interest without the consent of the other co-owners. That may be kind of hard to do, though. And owners can partition if one party wants to sell and the others don't. That could also mess up your joint tenancy. And it's possible to convert to a tenancy in common or tenancy in severalty. Yeah, as the other co-owners die off, you'll eventually have one last man standing, so to speak, as the owner. So then it would be tenancy in severalty. So how could it become a tenancy in common? Well, there's nothing to prevent you, if you're a joint tenant, from selling off your interest without the other's consent. But because you're selling off your interest, that new owner didn't have the 4 unities of time, title. All right, they got their ownership at a different time, using a different title, using a different deed. All right, so here, what form of ownership is this? You got 3 owners, equal ownership shares.
Interest?
What form of interest? What form of ownership interest is it? Is it tenancy in common or joint tenancy? You got 3 owners, equal ownership
Joint.
share.
It's
Joint.
a
You all
joint.
have
It's
equal.
a joint tenancy. Que se equal.
And
Trick
it's 2 or
question.
more.
And if you don't specify which form of ownership it is, it's tenancy in common.
Tenancy, yeah.
I'd have to tell you, because can you have 3 owners with equal ownership interest with a tenancy in common? Sure. But the thing is, in order to have the joint tenancy, you have to specify you want to take ownership in that form. So if I didn't specify that, right? I just said there's got 3 owners, equal ownership interest, what form of ownership it is. If I didn't specify joint tenancy, it's tenancy in common. See, I'm trying to keep you on your toes.
So tenancy in common is always the default. I see right here,
That's
default form of ownership. Got it.
That's
Okay.
a default form of ownership, 2 or more owners not married to each other. Yeah.
Got it.
Now let's just say that this is a joint tenancy. And what happens if owner B dies here?
And they've specified.
Now
Well,
they
no,
split.
No, this is a joint tenancy now. We got 3 owners, equal ownership shares. If owner B dies, what happens? What happens there?
Well, instead of it being 1/3, it now becomes 1/2. So you have 2 owners.
All right, so A and C split the ownership shares of B. There we go. You see that in this picture here? Where you
Yeah.
draw the line through?
They inherit.
Yeah, they automatically split the shares of the owner who died. And it doesn't need to go through probate or anything. It's automatic.
Did you say did you mention that there can't be, is there something about there being 3 partners in a joint tenancy that's not possible? Were
You
you
could-
gonna say something about the fact that you can't have equal ownership because it's 33.33?
no, joint tenancy must be equal ownership. Tenancy in common, it doesn't have to be equal. In order
Okay.
for there to be a joint tenancy, you have to have all the owners have to have equal ownership shares. If
Even
they
if it's an
don't,
odd number, like
if they
3,
don't, yeah. Well, if you have three owners, 33 and a third, that's equal ownership shares for three owners. Okay.
technically.
All
Almost. But
right.
okay, I get it. Okay.
33.33. Okay.
Yeah. Okay.
All right. So now what happens if you have owner B died and now A and C split the shares of owner B who had died? Now what happens if C dies?
A
Is
Owner A
get
becomes sole owner.
And what do we call that?
severalty of
There we go.
tenancy and
Now,
Tenant
now
severalty.
severalty.
there we go. Now
Ten.
they're owned as tenants in severalty. And now can A leave their shares in a will to their heirs?
Yes.
Yes.
Yeah, because he's the sole owner now.
Yeah, because they're now it's tenancy in severalty, and tenants in severalty can leave it in a will to heirs.
And this automatically defaults. You mentioned there's no probate or anything needed.
Correct. This happens automatically.
Okay. Cool.
It's the nature of the joint tenancy. It's the sole purpose of creating the joint tenancy that to have that for whatever reason. Okay.
Got it.
Want to know what reason? Well, talk to an attorney. It's legal advice. We don't give legal advice, so I don't even know why you'd want to do this. All
Got
right.
it.
Now we have how about this scenario? Here's a little switch up in the scenario here. We have three owners, A, B, and C. Nobody dies. Yay, we keep everybody alive here. But A and B, or rather C, is sick and tired of A and B's crap. So he sells his interest to D, who's a new owner. What did that just do to the joint tenancy? Well, the new owner D does not have the unity of time and title. They didn't get their ownership at the same time or using the same deed. So owner D is not a joint tenant. They come in as a tenant in common with A and B. However, A and B remain as joint tenants with each other. So if A or B dies, the other will automatically get the shares of the other.
And D is a tenant in common.
So they don't get nothing.
Huh.
However, right now, because D is a tenant in common, if D dies, can they leave their ownership interest to someone else? Yes, they can.
Yes, I can.
All right. So I got that whole scenario spelled out here on these slides too at the top too. So if you go through these slides, which are available to you in the shared Google Drive, you can, see that explanation once more time by reading up here. All right. So here we go. That's that scenario. So now if B dies, then A inherits their interest, and now there's no more joint tenancy. It's only a tenancy in common between A and D. So now either one of them can leave their shares in a will to their heirs. Okay. You good, Jonathan? Yeah. You look a little confused. You good? Okay.
I'll get it eventually. Sometimes it takes me a little bit. I'll review it and I'm like, all right, I got it.
I don't mind if you repeat this scenario one more time, Victor.
Yeah, let's do it again, please.
Let's start off from the beginning. We have a joint tenancy.
Yes.
Three owners, equal ownership interest, A, B, and C. B dies, A and C split their ownership shares, and they're still joint tenants.
Mhm.
C dies, they leave, last man standing is A. And so they now own in severalty. So they could leave their interests to, there's no more joint tenancy anymore. They could leave their interest in a will or sell it, leave it, give it to whoever they want. Now, if you have the scenario where A, B, and C are all joint tenants, nobody dies, but C, you could still sell your interest if you wanted to without the other's permission. So C sells their interest to D, a new owner. D does not have the four unities in common required to have a joint tenancy: the time, title, interest, and possession. So D comes in as an owner is
Oh,
tenants in common
tenants
with
in
A
common.
and B. And tenants in common, they could leave their shares in a will to heirs if they want, because D is not a joint tenant. So also, if A or B die, D doesn't get any of that because they're not a joint tenants. They're not privileged to that.
So what
But
happens if D doesn't leave it in a will and dies?
well, how does anybody? What happens to anybody's stuff when you die without a will?
Well, the state takes it
Well,
They,
and they
first,
put it
your
in S.
natural heirs, your heirs
Yeah.
can step forward first, but if it doesn't, then it goes through the process of the escheat, right? So, and then the state could end up with it. Yeah. Now, in this scenario, we got D here, who's a tenant in common, but A and B are still remain as joint tenants with each other. So once one of them dies, the other will inherit it, unless they sell it off as well. And then there would be no more joint tenancy either. So in this case, B dies, leaves A gets everything. So A now owns 2/3 of the property, and they're tenants in common with D. There is no more joint tenancy. Okay. Fully understood that time?
Yep.
All right. You don't got to look that far into it. It's really that simple. You know, it's just when you first get introduced, it's a little confusing. I understand, but it's not that difficult if you don't make it difficult. Just follow along, you know. All right. So now, tenancy by the entirety is ownership by married couples. So let's highlight that on page 123. Tenancy by the entirety is a special tenancy between spouses. And you could write married couples above that, because Governor Christie signed gay marriage into law in New Jersey before he left office. And so now gay couples could also um, benefit, and they could also reap the same horrors that the rest of us have to deal with in relationships. All right.
That's a good one.
Now, yeah, because this book used to say between husband and wife. Now they changed the terminology to between spouses. So I put in there married couples, but I also want to point out it's because of gay marriage. That's why they changed the vocabulary there. Now, the owner must be married. They must be spouse. They must be spouses when they receive the property. The owners have the rights of survivorship as well. Married couples with tenancy by the entirety have the right of survivorship, at least for the primary marital residence. You know, if your spouse dies, you get the house, right? They can't leave it to their girlfriend or boyfriend, their side piece, if there was one. That's what I'm saying. And there is no right to partition, right? If you're a married couple and you want to sell and your spouse doesn't, you don't take them to court to sue them to force them to sell the house. You guys got other issues you need to work out first if it's coming down to that, right? So there is no right for spouses to partition. Now, what's this other write-up they have down here? Let's read it. Let's see what this is about. In New Jersey, a conveyance to a couple who are legally married to each other or registered as domestic partners or members of a civil union in New Jersey creates a tenancy by the entirety unless the deed expressly states otherwise. In New Jersey, couples that are 62 years of age or older can register for a domestic partnership if they meet certain requirements. When a couple gets divorced, the tenancy by the entirety is broken and they become tenants in common. New Jersey does not recognize common law marriages. Under New Jersey law, a couple in a civil union are entitled to the same rights as a married couple, so that they can get the medical benefits and all that other stuff, you know. But anybody know what common law marriage is?
Yeah, you together for like 7 years and you automatically become married.
It's a misconception, yes, but that's what most people believe. But it's close. It's states that do have common law marriage, whatever the time frame is. If you live together for a long enough period of time and you're known by others to be a couple and you wish to be considered married, you don't have to go through the formal ceremony and you can be married and get all the benefits of marriage. Okay. So here, tenancy by the entirety. I put a slide together for you with a little more detail than what the book has. Ownership by married couples, the primary marital residence if married after May 28th, 1980, or to all properties if married before. We got those dower and courtesy rights where your spouse has an interest in all property you own during their marriage, right? Owners have the right of survivorship, so once one spouse dies, the other automatically gets the house. New Jersey does not have common law marriage. Let's click on that. And I got a link here that takes you to a website that talks about common law marriage. And let's see, there's a couple states that have it. Not many. Let's see. Some states recognize other states' common law marriages. Other states do not. So what states do have common law marriage? Let's see. A common law marriage is one in which the couple lives together for a period of time and considers themselves as married, but without ever going through the formal ceremony or getting a marriage license. Many people believe that a couple that lives together for a set period is considered common law married. However, this is an inaccurate belief. While common law marriages are recognized in several states, no states recognize a couple living in the same household for a specific number of years as being married. Common law married. So what states do have common law marriage? Well, let's see. As of 2018, 8 states acknowledge common law marriages through final legislation. Okay, well, which states still have it?
It says
In
Colorado.
Texas,
It says it right there. No, those states are Colorado,
no,
District of Columbia.
no, these are the states are these are states that recognize common law marriage. Let me see. Before we get into states with common law marriage, okay. Before we get into specifics surrounding common law marriage laws, let's identify which states acknowledge these relationships. As of 2018, 8 states acknowledge common law marriages through final legislation. Those states are Colorado, DC, which is not a state. Where'd it go? Iowa, Kansas. What the hell's going on here? Iowa, Kansas, Montana, New Hampshire, Texas, and Utah. The requirements to establish common law marriage would vary by state. In DC, marriage is legally recognized without a ceremony or a marriage license if both parties are legally allowed to marry and wish to be married, and if the community knows the couple as husband and wife. In Texas, there's 2 ways that a couple can enter into a common law marriage. Yeah, with a shotgun because you got her pregnant. Not kidding. So in Texas, there's 2 ways that a couple can enter into common law marriage. One way is the couple agree to marry, live with each other within the state, and represent to others that they are married. Couples may also file a declaration of informal marriage with the county clerk. While some states permit people to get married before they turn 18 with parental consent, some common law marriage states require that both parties be 18. Colorado and Kansas common law marriage statutes state this requirement. Okay. In some states, common law marriage is permitted only for a specific purpose. For example, Iowa acknowledges common law marriage simply for the support of dependents. In New Hampshire, common law marriages are recognized for just probate purposes. And here's some states that previously allowed common law marriage but got rid of it. Alabama got rid of it in 2017. Florida got rid of it in 1968. Georgia got rid of it in 1997. Indiana, 1958. Ohio, 1991. Pennsylvania, 2005. And South Carolina just got rid of it in 2019. So there's not many states that have it, and some states that did already got rid of it. All right. You don't need to know common law marriage for exams, though. Not going to get any questions on exam about it. Just that people usually ask during class, so I put a reference there. Okay, so when a couple divorces, ownership reverts to tenancy in common, which is the default form of ownership by two or more parties not married. And they no longer have the right of survivorship once they get divorced. No right to partition while you're married, only after divorce. A corporation cannot be a tenant by the entirety because corporations don't get married, people do. When corporations get together, they call it a merger. And when they break up, they get dissolved. And the right of survivorship, that's when one co-owner spouse dies, the surviving co-owner spouse automatically inherits the ownership interest of the one who died. And a partition, once again, is a form of involuntary alienation where one person sues the other, forcing them to sell or divide the property. When you get divorced, this is why the spouses can force the other one now to sell the property. All right. So to review, tenancy and severalty is sole ownership, one person or entity, one person or corporation, for example. Tenancy by the entirety is ownership by married couples. Tenancy in common, or TIC, is the default form of ownership where two or more people not married to each other own a property together, or two or more businesses, or an individual owns it with a business. Okay, that's tenancy in common. When you have a partial ownership share of ownership in the property. Joint tenancy, you can specify, you have to specify you wish to take ownership in this way when you have a partial ownership interest. All owners have to have equal ownership shares. Corporations can never own as joint tenants because corporations never die. They got that perpetual life existence. And you have to have 4 unities in common to create a joint tenancy. TTIP, time, title, interest, and possession. And what is the only benefit to having a joint tenancy? It is the right of survivorship. When your co-owner dies, the surviving co-owners automatically equally split the shares of the owner who died until there's only one left, right? So we should never give advice as to which form of ownership to take, even though you're going to study your hearts out, memorize the different forms of ownership. If a question asks you, how would you advise that they take ownership? The answer would be none of the above. If they ask which form of ownership would this scenario be, answer away. Okay? So let's now talk about businesses. We're not talking about real estate ownership anymore. Right now, we're just talking about business structures. If you have a business where there's only an owner-operator, we call that a sole proprietorship, right? That's one owner. Partnerships are 2 or more owners. We're going to go over different types of partnerships in a moment. Corporations are legally formed entities where you got to file all kinds of paperwork and have a lot of positions filled and do things according to the law. Although, you have to have these positions in place and everybody has to file paperwork with the state, make sure that it's the corporation's formed properly, those positions are filled. An LLC is not a limited liability corporation. It is a limited liability company. That's what C stands for, company. They get a lot of the same legal protections as a corporation, However, it's a little bit simpler to file the taxes. The income only gets taxed once through the corporation. And once that LLC starts making a lot of do re mi, they could start filing their taxes as an S corp for some additional savings in the tax department. Syndicates and joint ventures, they're not legally formed business entities. You don't need to file paperwork with the state to create a syndicate or joint venture and pay legal fees or filing fees, licensing fees. A syndicate is just the joining together of two or more people to carry out a business project. When the project's done, the syndicate's done. A joint venture is similar to a syndicate. However, instead of two or more people, it's two or more groups that they get together to carry out a business project. And when the project's done, the joint venture's done. And then we'll talk about the advantages of having a real estate investment trust or investing in a real estate investment trust, a REIT for short. What is a REIT, and what are the tax advantages to investing in REITs? You get the same tax benefits as mutual fund investors. All right, so the book Rewrite Screwed Up. This guy who's putting in these easy to remember things, he puts in this advice, these one-line zingers about how it's easy to remember this and that, but then he has a total misunderstanding of what the types of partnerships are. So we're going to cross out some sentences here because they're just flat out wrong. We're on page 123. It says, ironically, there's no general partner in a general partnership because all the partners participate in the day-to-day management of the business venture. Okay, well, actually, that's wrong. All partners are general partners in a general partnership because they all are owners and they all participate in the day-to-day business. So we got it backwards. So what is okay, we're going to go over, there's two types of partnerships. There's a general partnership and a limited partnership. A general partner is a owner of the business that also works in the day-to-day activities of the business. They participate in the business. And they can be held liable for any additional debts that business should take on. In a general partnership, all the co-owners are general partners. They work in the day-to-day business. Whereas in a limited partnership, they have at least one general partner that works in the day-to-day business, that's an owner, and all the other partners are limited. They're limited because they do not work in the business. So they're limited as far as their risk to be required to pay any additional debts if the business takes on any additional loans. They're limited in their liability to the extent of their initial investment in that business. That's all the money they can stem to lose if the business loses money. Okay. Let me give you an example of a limited partnership. You want to start a business, right? So you go to the bank of mom for a loan. Mom don't care anything about your business. She just hopes you're successful in all your endeavors in life, right? So she's there to support you. So mom gives you a loan to start the business. Mom is a limited partner. She's not working in your business. She knows nothing about your business. She's just an investor in it. So if you should need to, you're the general partner. If you should need to take out additional loans for that business for whatever reason, mom is a limited partner. She can't be required to pay back that loan. Only the general partners do or are. Okay. So here we go. Here's the two definitions straight up without all the scribbling. Uh, so general partner, well, I wrote up top two types of business partnerships. All partnerships have at least one general partner. General partnership, all the co-owners are general partners. General partner works in the day-to-day activities of the business and can be held liable for any additional debts the business takes on. In a limited partnership, it has at least one general partner and the rest are limited. They do not take part in the day-to-day activities of the business, and therefore they're limited in their liability to the extent that they cannot be held liable to repay additional debts the business takes on. They can only lose their initial investment in the business. All right. Ownership by corporations. Corporation's an artificial person. It's a fictitious entity for taxation and legal protections. Corporations cannot own real estate as joint tenants or tenants by the entirety because corporations' life is perpetual existence until it is formally dissolved. It would always be that last man standing, so to speak. And corporations can't be a tenant by the entirety because corporations don't get married. People do. When corporations get together, it's called a merger. So corporations can only own real estate in severalty or as tenants in common if it's a partial ownership. Now, who makes all the decisions in a corporation to buy or sell real estate? Well, corporations are managed by its board of directors. They're the ones that are supposed to be looking out for the best interest of the stockholders. And they make decisions based on protecting their investors, right? Because without those investors, you wouldn't get the money when you needed it. If you needed a cash infusion as a business, right? You need people to invest in your business. And if you start showing a pattern of not looking out for the investor's best interest, could that lead to issues in the future of getting investors? If you show that you piss away their money because you're not looking out for the investor's investment, right? If you start, for example, investing in social issues because you're now got somebody that's a social justice warrior of some sort that they want you to donate all their money to, say, the backing up causes or to certain groups like that try to make sure that they'll give you a positive image. Otherwise, if you don't invest in them, they'll slander you and say that you're racist. Where did this happen recently? We've had groups like Black Lives Matter did that to a lot of corporations, right? They were going to them and saying, "Hey, if you don't support us, then you don't believe Black Lives Matter." See that was a catchy name for those scam artists that started that group. Um, you know, all those members that created it are in jail now, right? for money laundering and taking the money out and using it for their own self-interest instead of for the nonprofit purpose it was supposed to be meant for. They came up with a good name because who's going to say that Black lives don't matter, right? So what they started using is they started going to corporations and using that to twist their arm to get hundreds of millions of dollars in donations. And then you had other groups that were pushing agendas for like the trans agenda, the transsexual agendas and things of that nature. How did that work for Bud Light, for companies like Bud Light, right? You had one division, you had a president of a division of Bud Light who decided she was going to start creating her own advertising campaign, I guess, without running it by the board of directors. And it kind of backfired majorly because they still to this date have not recovered yet, losing billions of dollars in profits, and they still haven't recovered. How many people here want to buy stock in Bud Light now? I'm sure it's really affordable. The price went down a lot. Why not? Because they showed a pattern of not looking out for the investors' money, right? So this is exactly what I mean. So who makes all the decisions in a corporation? the board of directors. Now, they're supposed to look out for the shareholders' interest. So a corporation can convey real estate only upon a proper resolution being passed by its board of directors. So who makes all the decisions in a corporation to buy or sell real estate?
The board of directors.
The board of directors, not the president or CEO. They're not supposed to be doing that stuff unilaterally anyway. And the board of directors should be stepping in when they do try to do that, like with Bud Light with their campaigns. But when it comes
on the board,
huh?
How about they're on the board?
They're probably on the board, but it has to be a
unanimous vote
by the entire board.
By the entire board.
Okay, so now it's a little bit. So the corporation, the board of directors usually makes those decisions to buy or sell real estate. There are a twist to that, and that's when all or a substantial portion of the real estate owned by the corporation is being sold. In that case, it's not this decision that's just made by the board of directors, but also by the stockholders. They need to get the stockholders to vote on it too. So we'll see that on page 366. I got a little cross-reference here for that. So do these highlights here and then go to page 366 where it says a corporation is managed and operated by its board of directors. Okay, so somebody comes into your office. They want to sell or buy real estate for a corporation. Do you have that person sign the documents, or do you need some kind of proof that they're the representative of that corporation?
You need proof.
You need a resolution that was passed by the board of directors saying that this person is in charge of buying or selling real estate for the corporation in this instance.
Now, does that have to be notarized, or it doesn't matter?
It should be. It should be, but we'll go over that in just a moment. After we get these highlights, we'll go to page 366 and take a look really quick. Take a little peek. Okay, y'all got that?
Yes, sir.
Okay.
Yes, sir.
So now if we go to page 366, I think this is at the bottom of the page, you could see execution of corporate deeds. So under the law, corporations considered a legal entity, and 3 basic rules must be followed when corporations are to convey real estate. 1, a corporation can convey real estate only upon a proper resolution passed by its board of directors. 2, if all or a substantial portion of the corporation's real estate is being conveyed, it is also usually required that a resolution authorizing the sale be secured from the stockholders, the investors. And 3, deeds to real estate can be signed only by an authorized officer. The authority of the officer must be granted by a resolution properly passed by its board of directors. And if there's a corporate seal, the corporate seal need not be affixed to the conveyance unless there's an acknowledgement that mentions the seal that it needs to be fixed. Okay. So, yeah, I guess they didn't talk about notarization or anything, but it probably should be notarized there. Okay.
Yes, sir.
And back to page 124. Syndicates and joint ventures, like I've already explained, that they're not legally formed business entities. A syndicate is just 2 or more people getting together to carry out a business project. You don't have to file paperwork to form the syndicate. It's like you and I, we go halvesies on buying an investment property that we could fix up and flip. After we fixed it up and flipped it and sold it, the syndicate's done. Okay. Whereas a joint venture, It's two or more groups that come together to carry out a business project. And when that project's done, the joint venture's done. A REIT is a real estate investment trust. It's a form of organization useful for taking advantage of certain tax benefits. Who says that you need to invest in mutual funds for your retirement plans? Why not invest in a fund that invests in real estate instead of tax and instead of businesses and bonds and things of that nature? You know, in order to have a REIT, it must have at least 100 investors, qualified investors, whatever those qualifications are, probably that they have a lot of liquid cash, has to have at least 75% of the trust income must come from real estate as the investment vehicle. And it's a stable investment that pays out slowly and steadily over time. Just like mutual funds. They're fairly safe investments. They're low risk, but they pay out slowly over time. An example of REITs invest in, like, they buy large apartment complexes and buildings and such like that. You can be sure that the majority of the tenants are paying their rents, right? Yeah, you get one here and there that doesn't pay their rent. They got to get evicted. That's part of doing business, right? But overall, the apartment complex is profitable because most of the tenants are paying their rent, right? So if it is a REIT that owns that complex, the REIT investors are reaping the rewards slowly over time. The only time where they get a huge payout is if the REIT decides they're going to sell the entire complex and they sell it at a profit. Okay. I've had a REIT come to me before once looking for apartment complexes. They're like, yeah, we're looking for several hundred units. Our minimum investment is usually around $10 million. And I was like, oh, I wish I had that kind of listing. So they gave me their business card and that was it, So REITs can have large apartment complexes with several hundred units. They could be high-rise buildings, business centers, or shopping centers, etc. Okay, so here's on page 124, the highlight, and on page 333. Real estate investment trust, REITs, is a form of organization that's useful for taking advantage of certain tax benefits. What tax benefits? And then I wrote here, same tax benefits as mutual fund investors. They get the same tax benefits as mutual fund investors. And this last one, this is on page 333.
Got it.
Okay, everybody good?
Yes, sir.
Okie dokie. So back to page 124, 124. Let's talk about condominiums and cooperatives now. Let's just throw out an attendance poll for the morning here. All right. Condominiums and cooperative ownership of housing has risen in the second half of the 20th century, together with townhouses and planned unit developments referred to as PUDs. Condos and co-ops offer the emotional, financial, and tax advantages of home ownership combined with the various advantages of apartment living. As opposed to traditional single-family homes, which, by the way, can be condos as well. They could be part of a condo complex. Condos and co-ops offer more efficient use of ever scarcer building land, lower cost for lot development, less outlay for construction per living unit, and in some savings in the maintenance and heating bills. Contributing to the growth of condos and co-ops are changes in our society, right? Changes in population patterns with increasing number of single homeowners, one-parent families, and senior citizens. To such groups, community living offers security, sociability, ease of maintenance, and sometimes the opportunity for sharing expensive recreational facilities like those Olympic-sized swimming pools, exercise rooms, IMAX movie theaters, pool rooms and board meeting rooms, ballrooms that could be reserved, tennis courts, and so on and so forth. So the term condominium and cooperative refers to the forms of ownership. And simply looking at shared housing complex gives you no clue as to what form of ownership it is, whether it's a condo or a co-op, or in some cases, a planned unit development, the PUD. The buildings themselves could be high rises, townhouses, patio homes, garden apartments, or even single detached houses. The differences arise from their legal form of ownership. And condominium ownership is not limited to residential dwellings. We have business condo complexes as well. So cooperative ownership is common in New York City, and it's also found in certain areas in New Jersey. Cooperative ownership became popular in the 1920s as the urban population grew after World War I. Individual housing became more expensive, and the boards of directors were choosy about who can buy in. The numbers of newly built cooperatives have decreased greatly over the last 50 years. Yes, okay, so the boards of directors that are running co-ops can be choosy about those who move in, trying to protect the tenants, the tenant owners. Because if you get a bunch of them that do not pay their monthly maintenance charge, which goes towards an underlying mortgage on the entire property and the property taxes, it could put all those other tenant owners in jeopardy of losing their property as well. So because they're choosy about people that they allow to buy in, yes, they've been accused of discriminating a lot. But that's a natural thing, if you're rejected for an application that you feel like that you've been discriminated against. Has discrimination ever occurred? Yes, I'm sure. But listen, here, let me give you an example of this. Maybe in New York City or in areas of California or New Jersey, even with, let's just say like Hoboken area. They're an artsy fartsy area, right? Let's just say that an area like Hoboken, they have a cooperative building that they do their interview process, and they're snobbish, and they're like, yes, we are an artist community. You have to be an artist to be accepted here. Are you a painter? Are you a musician? A writer, a dancer, some sort of artist of some sort. And if you're not, then they reject you. Sure, being rejected always feels bad. That's what they mean by being choosy, and people feel like they're discriminated against. But let me ask you a question. Is being an artist or not a protected class?
No.
So therefore, they can reject you all they want, and there's nothing you can do about it if you're not an artist. Right? An actor, a dancer, a musician, a writer, a poet, right? So under the usual cooperative agreement, title to the land and the building is held by a corporation. corporation owns the land. So each purchaser of an apartment in the building receives stock in a corporation and a proprietary lease. Proprietary is a fancy word for custom. You got yourself a custom lease, which gives the purchaser the right to occupy their apartment. The cooperative building's real estate taxes are assessed against the corporation as the owner of the real estate. And there's usually one underlying mortgage on the entire parcel of real estate. Taxes, mortgage, principal, and interest, and the operating and maintenance expenses of the property are shared by the tenant shareholders in the form of their monthly maintenance fee, their monthly maintenance charge. Some people call it CAM, Common Area Maintenance Charge. So thus, even though co-op owners do not actually own real estate, you guys hear that? Co-op owners do not actually own real estate. They own stock in a corporation that owns the real estate. It's very important to understand that. They own stock in a corporation that owns the real estate, and they're given permission to live in that unit that they live in using a proprietary lease. Now, for all practical purposes, they control the property through their stock ownership and their voice in the management of the corporation. Co-op bylaws generally provide that each prospective owner must be approved by a board of directors, and they usually have minimum credit score requirements like 620. 620 is considered prime. That means average. Okay, if you got below 620 credit score, in most co-ops, you're not getting in if you have a below average credit score, because that means you don't pay your bills on time. And if enough tenants don't pay their bills on time, what can happen to this corporation that owns the real estate? That's right. They could not be collecting enough money to pay their important bills, like the mortgage on the entire property. So it could, and the taxes, which could affect the ownership of all those other co-owners that are paying their bills. That's why they're very selective and choosy in those interview processes. They want to make sure that you're going to get people in there that are responsible and do pay their bills. And that's why they got their minimum credit score requirement as well. And yes, some of those buildings can get very snobby as well and have things like, we only allow artists. This is an artist community, or whatever their reasons are. But as long as they're non-discriminatory. Okay, so, did everybody get all these highlights?
Yep.
Okay. One disadvantage of corporations is it's possible that if enough of the owner occupants become financially unable to make their prompt payments of their monthly assessments, the corporation may be forced to allow mortgage and tax payments to go unpaid, like I was talking about. This was actually a problem back in the 1930s, and through such defaults, the entire property could be ordered sold by a court in a foreclosure suit. Such a sale may destroy the interest of all the owners, even those who have been paying their assessments. Accumulation of substantial funds of reserves for future repairs and emergency payments. What are reserves? You need to know the definition for reserves. Reserves is an accumulation of substantial funds for future repairs and emergency payments. That's what reserves are. You'll have that term on exam, so you should put it in your definition list. Now, the cooperative shareholders have an income tax advantages, have all the same income tax advantages of the owner of a single family home. That a portion of their maintenance charge attributable to property taxes and mortgage interest could be taken as income tax deductions. Interest paid on finance to finance the stock purchase is also deductible. Oh, wait. Can you get a mortgage loan to buy a co-op?
No.
Why not?
Because not property. It's
Well, okay. So let's word that a different way. You do not own real estate when you own a co-op. You own stock in the corporation. That's what she was saying. So, yes, that's correct. When you own a co-op, you do not own real estate. You own stock in a corporation. So you're not getting a mortgage loan, because what is a mortgage loan? What's a mortgage? It's a promise to pay. I promise to pay you back according to the terms in the note. And if I fail to do so, you could foreclose on me, sell the property at auction, and use the proceeds to pay off the debt. But you can't do that when it's a co-op, because you don't own the real estate. You own stock. So how do you buy a co-op? Either cash or personal loan. So most co-ops do not permit rentals. Why? Who takes better care of the property? Renters or owners?
The owner.
And in co-ops, you got a lot of when you buy a co-op, when you buy into a co-op, I should say, they're a lot cheaper than buying a condo. Like you could get a 2-bedroom, 2.5-bathroom co-op and a 2-bedroom, 2.5-bathroom condo. And 2 different complexes. One is condos, one is co-ops. They all have all the same exact features, amenities, and everything. Your guests will not notice the difference because it's the form of ownership, and your guests won't notice the difference. But let's just say that condo could be 300 grand. That co-op, the exact same structure and building with all the same features and everything, could cost you 75. You could get into it a lot cheaper. The only difference is the monthly maintenance charge in co-ops is much higher. Why? Because you don't get a separate property tax bill or insurance bill. You get a renter's bill. You pay renter's insurance, right? You don't get a property tax bill because you don't own real estate. You own stock in a corporation. However, the corporation collects the money to pay the taxes through the monthly maintenance charge. Often, heat and hot water and sewage is included in the monthly maintenance charge as well. So the monthly maintenance charge is higher on them, but they're cheaper. I mean, you could get one co-op for the, or you could get 3 co-ops, 3 or 4 co-ops for the price of one condo unit. So a lot of people automatically, damn, I'm going to buy some co-ops and rent out the other units, right? And most co-ops do not allow rentals. Most. Can you come across some that do? Sure. But most do not. Because if the ratio of renters become too high, people may have trouble getting financing. Now, a New Jersey law provides that owners of co-ops and buildings with at least 10 units are allowed to rent their units if they're unable to sell them for 4 or more months at a price no greater than how much their initial investment was. So if you're not able to sell it for how much you bought it for 4 or more months, then you're allowed to rent out your units. But it's only in complexes with at least 10 or more units. All right. So let's get some notes here. Title to the land is held by the corporation as the owner. So purchasers do not actually own real estate. They own stock in a corporation, which is an intangible personal asset. Proprietary lease is a fancy name for a custom lease, which gives the tenant stock owners the right to occupy the units they're living in. Income tax advantages are identical to those of single-family homeowners. The tenant has a voice to control their property management through the stock ownership. Maintenance fee is usually much higher than condos because it usually includes the mortgage, taxes, insurance, and CAM, common area maintenances fees, which include sewer, water, heat, trash, and snow removal. The value of the property tends to be a lot more stable and does not fluctuate as radically as it would for condo ownership. You know how real estate markets are cyclical, they go up, they go down. Well, that line's a lot more steadier. It goes up and down for co-ops as well, but it's a lot more steady. It's a lot more stable. There's not radical changes in the values of them. So why would you want to buy one? Cheap place to live. Yeah, just throwing that out there. So shared expenses, there's usually one mortgage on the entire underlying property. Tenant shareholders, taxes are charged to the corporation as the owner and billed to the tenants as part of their monthly maintenance fee. Bylaws require each purchaser must be approved by the board of directors, which manages the corporation. Usually has a minimum FICO credit score requirement of 620. Most do not permit renting. If there's too many rentals, people may have difficulty obtaining financing to purchase other units. But there is a law that allows rentals of 10 or more units, and the owner has tried to sell for at least 4 or more months at a price no greater than their initial cost and were unable to sell it. Then they're allowed to rent it out. Long-term stability of tenants is common, and you could finance the purchase through cash or personal loans, not using a mortgage loan because it's not backed by real estate. And real estate agents cannot prepare sales contracts for co-ops. They must be prepared by attorneys because you're selling stock, not real estate. You know, when I sell co-ops, I usually charge more commission too. A lot of people do. It's not uncommon to charge 8 to 10% commission for selling a co-op because they're much cheaper, right? So charge higher amount to try to market it so that you could make something off of it. All right, so the first condos were built in Puerto Rico in 1958, and the FHA was allowed to insure mortgages for condominiums by 1969. Many people were introduced to condominium ownership in Florida, which had introduced the concept from Puerto Rico. Popularity stems from the ability to obtain affordable housing, often in highly desirable areas that are typically beyond the economic reach of most to buy beachfront properties, right? So buyers of condominiums receive a deed conveying fee simple ownership of two things: everything from the paint on the interior walls inward and a proportionate undivided interest of the common area elements. So what do you own when you own a co-op? Everything from the paint on the interior walls inward. In other words, you can't go smashing those walls out to start messing around with the plumbing because all of those units are tied into the same plumbing. The plumbing is not yours. It's owned by the condominium complex, the management. You need to get permission to tie into it or break into the walls and start messing with it. So chief among the common elements are the land and the exterior of the building. Common property could also include the hallways, basements, elevators, stairwells, driveways, private roads, sidewalks, lawns, landscaping, and those recreational facilities. In many respects, condominium ownership could be regarded in the same light as the owner of a single detached house. Title can be held in severalty by the entirety as joint tenants or tenants in common. The unit receives an individual tax bill and may be mortgaged like a house would be. The owners place a separate insurance policy on their living space, and income tax advantages are identical to those of single-family homes. The owners are free to sell the property, lease it, or give it away, or leave it to their heirs. Each unit's a financial entity, and if an adjoining unit is foreclosed, it doesn't affect the other owners, unlike co-ops. So owners are, however, bound by the bylaws of the homeowners association to which all will belong. So as long as the rules are not unreasonable, New Jersey law does permit condo associations to enforce their rules by fining residents who fail to comply. Yeah, it's kind of like your local towns, city council and mayor, right? They could come up with their own rules for their municipality and fine residents who fail to comply with those rules, right? So think of a condominium as like a mini municipality within a municipality. Um, Everybody who owns a condo in the complex becomes a member of that homeowners association. But do you buy a condo so that you could get involved in politics and management of that corporation that or management of that complex? No. Most people do it just to have a place to live. But they need some people to be running and creating these rules and enforcing them. So what they'll do is they'll get a couple of volunteers who are also homeowners there that will then get voted in to be on the homeowners association board. Okay. Now these are people who are usually bored, got nothing to do, and then the power goes straight to their head. It is not uncommon for them to start running the complex like a bunch of Nazis, all up in your business, walking around with the clipboard. You're violating the rule. This is your warning. 3 warnings and you get a fine. They start getting, listen, I sold a lot of condos. I actually made a lot of money in real estate just by selling condos. I, like most people, started getting into it because I wanted to sell those mansions, those multi-million-dollar homes. But yeah, those people are tough to deal with, snobbery and all. But I found myself working more with investors and people who are buying condos, affordable homes, basically condominiums. And I found that it was my niche, so I started focusing on it. Even started marketing myself as the condo king. I know, kind of cheesy, but hey, you do whatever works, and it worked pretty well. And so I became familiar with the nuances of selling condos. Like you could have 2 condo units in the same building, and they're exactly the same, but one sells for a lot more than the other. And you could scratch your head trying to figure it out. But do you know that some condo?
No,
What's
let's say
that?
I wouldn't necessarily scratch my head because it could be like, are they located in the first floor versus the 13th floor?
Let's say they're
Um,
both. Let's say they're both on the same floor. All right, and the same square footage, same updates. Everything is exactly the same about them. Not like one unit's older, one unit's newer, or one's
by the
they have
elevator?
updates. They're all exactly the same, exactly the same. Okay, but one sells for considerably more than the other. I found that a lot of times this could be, some condo units can come with deeded parking spaces that you own,
Hmm.
or one condo unit can have a basement, like a 10 by 10 room in a basement
For
somewhere in the
storage.
building for storage where the other one does not. These can add to the value of the unit. Okay. So this is why you gotta probe more and ask more questions when trying to get listings of condos to see if there's anything unique about that unit versus others, so that you could price it appropriately. Okay. You don't just go by what other ones have sold for, because if the other ones didn't have that extra storage unit or a deeded parking spot, hey, parking spots can be a lot of money. Look, there's some condos like look in New Brunswick where parking's at a premium, right? And they got parking garages to park off street, and maybe you get one parking space, or maybe you have to lease that parking space. If you got one that's deeded that you own, well, that could save you a lot of money. It could be worth a lot, right?
Yep.
So, let's see. Let's continue reading here. So, New Jersey law permits associations to enforce their rules by fining residents who fail to comply with them, as long as those rules are not unreasonable. Unreasonable. All right. With the big air quotes on that one. However, while condominium boards can stall or exercise the right of first refusal if it does, they rarely have the right to file to evict an owner. Monthly fees are levied for the maintenance, insurance, and management of the common elements. And if unpaid, these common charges can become a lien against the individual units and may even be enforced by foreclosure. The bylaws also set up covenants, conditions, and restrictions called CC&Rs. Okay? And they could prohibit you placing a for sale sign on your front lawn or even in your window, or painting a front door bright red or orange or some other weird color. A condominium is governed by its board of directors, consisted of often elected volunteers who actually live in the building. As fiduciaries, they have all the responsibilities of loyalty, care, duty to protect the community. They should have enough time to be involved and possess knowledge of accounting and good business practices to preserve the protected asset and protect the assets. And the day-to-day operations of condominiums are generally handled by a condominium manager. In New Jersey, the creation of condos are regulated by the state's Horizontal Properties Act and the Condominium Act. New Jersey Condominium Act applies to condos created after January 7th, 1970. So, in order to create a condo from scratch, you buy a piece of land, you want to build a condo. The owners of the property execute and record a master deed, and they file it in a public record in the county where the property is located. And many items must be contained in or attached to that master deed, including a legal description of the land, a graphic description of the buildings and other improvements, which identify the individual units by letter, name, or number, or a combination of both, and specifies a percentage of the common elements, if any, are included in the ownership of each unit. A description of the common elements, and a provision for an association of unit owners, and a starting out list of bylaws to create the condominium. So, when you own a condo, you receive a deed getting fee simple ownership of two things: their living unit from the paint on the interior walls inward, and a proportionate undivided interest in those common area elements. HOA, Homeowners Association, all unit owners will be a member of. Bylaws, or CC&Rs, those covenants, conditions, and restrictions, are the rules and regulations that all the homeowners need to follow. And so you want to do an open house in a condo? Can you do an open house in the condos?
Yes.
I would say yes.
Probably by appointment only. Otherwise, how do you find the units? They don't allow you to put signs out front or even in your unit front window. So what are you going to have? You're going to go around in a complex with those directional arrows with the balloons pointing to the unit that's having the open house, just to, as you come back around to the beginning of where you started laying them out, to see that maintenance is putting them in the garbage dumpster, pulling them out of the ground. So yeah, you probably have to do it by appointment only. Kind of defeats the purpose of an open house, though. So, but yeah, you could advertise an open house for Sunday or whatever, but people are going to need to make appointments for it. Especially if it's in a building with security guards, they'll have to let you in, or the real estate agent has to come down for each person and bring them up. All right, so they may not allow you to have that for sale sign or paint your front door a wacky color, allow you to put decorations out front or flowers even. They may not allow you to have a grill on your deck because there's a separate area for grilling, so the smoke isn't going into your neighbor's units or what have you. They may restrict oversized vehicles or commercial vehicles from parking in the parking lot. That's not uncommon. So vehicles with car wraps, well, car wraps are usually put on vehicles that are commercial. So one of the slides coming up, I'm going to show you a goof of some invasive rule enforcement by condominiums. So, hey, all stereotypes are based on some sort of fact, right? So we'll see this one over here about condominiums. Now, HOA fees, the owner pays a monthly association or maintenance charge for which we call CAM, the common area maintenance. And if left unpaid, they could be enforced by foreclosure. They're each, let's see, it's managed, the condo complex is managed by its homeowners association board. Professional management is usually hired if there's more than 25 units, but not always. Not always. Okay, here's that. I think it's a Geico commercial. And look, they're goofing on some of the invasive stereotypes of those people who are elected to manage on the board of the homeowners associations. They really get into it. The power goes right to their head. Take a look. Oh, by the way, look at the architectural style behind them. These are single detached houses, and it's considered a condo complex that they're in.
Oh, we love our new home. Neighborhood's great.
Amazing school district. The HOA has been very involved.
These shrubs aren't board approved.
You need to break down your cardboard.
Thank you.
Violation. Violation.
I see you've met SIP. Yep.
At least Geico makes bundling our home and car insurance easy.
And does help us save a bunch of money.
2 inches over regulation.
Thanks, Cynthia.
For bundling made easy, go to geico.com.
I mean, she's out there, got the husband with the clipboard, and violation. Let's cut down these plants. You didn't get them board approved. You got to break down your cardboards. They're all up in your business. That's what I meant. Usually, I sold a lot of condos in my time, and a lot of people, other than if they were upgrading their family size was growing and they needed a bigger place, a lot of times they really loved the place that they were living. However, the management was a pain in the ass. They kept it beautifully, but it was a pain in the ass. So they were moving out because of that type of behavior from these people where the power went straight to their head, always in your business, So here's another example I have from realtor.com. Got an article here where a condo association, this is in California, of course, a condo association started requiring the condo unit owners to leave their garage doors open during the daytime. Could you imagine? Isn't that a way for people that they could get into your house and break into your house through the garage? Or they could go in and start stealing stuff. Now what? You can't store your stuff in your own garage for security because you got to leave the garage door open. And why is that? Well, they said that some people were finishing up their garages and then renting them out for people to live in. Okay, but that's kind of ridiculous requirement, requiring everybody to keep their garage door open now. I wouldn't want to live there, would you?
I don't know.
That's crazy. But nonetheless, there you go. HOA makes homeowners leave garage doors open for a truly silly reason. Look at that. I mean, it's kind of like the armpit of your house, right? You keep your car in there and all kinds of other storage stuff, decorations, and all kinds of other belongings, But it gives people the opportunity to break in your house and steal crap too. Or you face a $200 fine. So you have to keep your garage door open from 8 a.m. to 4 p.m. Monday through Friday, or face a $200 fine. That's ridiculous. And then they give another example. Hold on a second. I got another story here from realtor.com where my HOA forced me to buy a $500 mailbox. Yeah, they got kind of out there. Check this guy out. Man battles his HOA for 7 years over a $500 mailbox and eventually wins. So look at that. This guy, he bought his own custom cute little mailbox, and and then shortly afterwards, the association sent out letters to everybody. They got to pay $500 because the association is going to be replacing everybody's mailbox with some kind of a gaudy one that they wanted a standard mailbox. So turns out this mandate came from, let's see, the Strong's Homeowners Association, or HOA, which had deemed that certain mailboxes in the community were looking run down. So the board decided to require that everyone upgrade for uniformity's sake to the same rather than the homely cast aluminum models costing $500 like this. So this was a $500 mailbox that everybody had to use.
That's the mailbox.
That's the $500 mailbox that everyone had to have.
Mm-mm.
And in the meantime, this guy made himself a nice custom mailbox that matched his unit, had like cedar shake shingles on it, you know, kind of looked like
just went to Home Depot, paint matched the
yeah, with some
mailbox and the spray painted his own.
yeah, with some what's it, army green or gray paint, whatever the hell color
Not
that is.
$500 worth of anything. Wow.
So on principle of it though, he was like, nah, I ain't doing this on principle. This guy, Strong, he's a solar physicist with NASA who paid $35 for a charming and functional cedar mailbox just a month earlier. Wasn't buying into that line or the fancy mailbox. So he fought them, and he fought them in court over 7 years, costing him $33,000 in legal fees. He spent $33,000 in legal fees to avoid buying a $500 mailbox on principle. So the litigation fees, roughly the price of 66 of those fancy mailboxes that he refused to buy. Still, Strong was never, it was never about the mailboxes. I care about the precedent, he says. We just put a new roof on our house that cost over $100,000. What would stop the HOA from coming back and saying, well, we don't like cedar roofs. You've got to put a new roof on that meets a different look or requirement, you know? And he's right, you know, but that's why he eventually won. But he should have also gotten the legal fees paid back to him too, though, for that lawsuit. See, so HOAs versus homeowners, how far can it get? Any homeowner in such a community knows the HOAs have a lot of rules, all with the purported goal of maintaining the neighborhood's safety, appearance, and property values. And the rights backed up by none too idle threats to fall upon the steps and face fines, even expulsion. So Strong faced fines of $100 for every month his home lacked the magic mailbox after the HOA's deadline of January 2013. He refused to fork it over and attended board meetings to air his grievances. Although some of his neighbors agreed with him, many caved for fear of making waves or even being foreclosed on. So Strong took his case to court. Some said we weren't trying to bankrupt our own HOA, but we actually only sued them for $1. So he didn't even fight to get all the legal fees back. He sued them for $1 for basically the premise, you know, for the principle of it. And he won. So there we go.
We love our new.
All right. So creations of condominiums are regulated by the New Jersey Horizontal Properties Act and the Condominium Act. Certain tenants may not be evicted during condominium conversions. Owners, which we're going to go over on another slide, but we already went over, I believe, in chapter 1 or 2. I think we went over it as well. We're going to go over it again. Owners of condos have income tax advantages identical to those of single-family homeowners, and condos can be any architectural style. They can be single-family detached houses, multi-unit attached housing, high-rises, garden apartments, townhouses, and so on. And remember, reserves are an amount of money saved up for emergencies and repairs. Look, you could have a winter that has a lot more snowfall than normal. So the complex needs to have money in their reserve accounts for that extra snow plowing and ice removal and salting and such. If the condo gets sued, then they have to be able to defend against it. And by the way, if a condo complex is involved in a lawsuit, good luck in selling your unit. Most attorneys will advise people not to purchase in a condo complex until the lawsuit is settled. Otherwise, you're buying into a lawsuit that you may have to be responsible for paying into. There should be at least 2 to 3 months operating expenses to run an entire complex in the condominium's reserves account. Otherwise, it's probably being mismanaged and your monthly maintenance charge is going to go up in the future. There you go. I just gave you guys a little tip there. And this is what attorneys look for when somebody's buying a condo. You're going to need to get them a copy of the bylaws so that they know what the rules are. And you're going to need to ask them for a copy of the management, for a copy of their accounting. And they'll usually prepare the last 2 to 3 years of finances in their accounting report. And they'll provide that. And I asked an attorney, when I was selling all these condos, what exactly is it that you're looking for in the financial reports? And he said, well, mainly you want to see, first of all, if there's a lawsuit that may be pending. And second, you want to really look to see how much money they have in that reserves account versus how much they spend to maintain the entire complex. You should have a minimum of 2 to 3 months reserve. So if the complex didn't take in another penny, they have at least 2 to 3 months in their reserves account to maintain the complex. Okay. If they don't, that's a sign that it's being mismanaged. And you're probably going to see your monthly association fees going up in the near future. Okay. And it's true, because just like a government, just like government, you guys ever go down to City Hall? You see like this, the lady working down at the window at City Hall, whether it's a tax window or a window where you're going to get a permit for something. And then her kid's working back there with her. Her young teenage son or daughter is back there working with her. You guys ever see that? It's like the whole family works down at City Hall. You don't see that at all. It happens a lot more than you think. And basically, that's nepotism. Those jobs are supposed to be going on a public board so that the most qualified person gets those jobs. But a lot of times, you're seeing their family members getting those jobs instead. That's nepotism. That's favoritism. Because you know somebody, you get the job. The same thing happens in the condo complexes on these HOA board, on these homeowner association boards, where you get somebody who's on the board and they're like, well, you see this lady, she's on the board and she's like, my husband should be the landscaper for the complex. He owns a landscaping business. And then they all vote to make her husband the landscaper. Oh, yeah, well, my wife's an attorney. We should put her on retainer for the complex. Now, they're not taking bids for the best person for the job at the best price. They're just giving it based on who they are and who they know. And that's mismanagement. All right, so I put together this little comparison for you, condominiums versus co-ops. You own real estate when you have a condo. With a co-op, you own stock and you get a proprietary lease. You get a mortgage bill with a condo. Co-ops, well, it's cash or a personal loan. You got to pay the common area maintenance charge in condos. You get a tax bill with condos, not with co-ops. You get a CAM charge with condos for the common area maintenance. Co-ops, it's higher because they include the taxes and maybe an underlying mortgage if there's one on the property still in your monthly maintenance charge, as well as the heat and hot water is often included. HOA applications required for approval, not for condos, but it is for the co-ops. There's a minimum credit score requirement for co-ops, but not for condos. The management of a condo is done with a homeowners association. Co-ops are managed by a board of directors. Insurance fee, homeowners, condos got to get their own homeowners insurance. Co-op owners, they get renters insurance. Condos can be rented, co-ops, usually not, except if there's 10 or more units and you've been trying to sell yours for a price no greater than you initially bought it for at least 4 months without success. Income tax advantages are identical for both condos and co-op owners. And your neighbors can be affected when you own a co-op if enough people aren't paying their monthly maintenance charge. Doesn't apply to condos. In a condo complex, individual condo unit can get foreclosed on. Doesn't affect your neighbors. Okay, so if I have a multifamily house or building, multi-unit building, I can convert it into a condo. I can buy a small apartment building, convert it to condominiums where each unit is deeded and sold and owned. But what's required to convert an apartment building or a multifamily house to condos? Well, creation's regulated by the state's Horizontal Properties Act, and it requires approval 3 years and 2 months before the conversion can start, if it's not completely vacant. Because there may be tenants there, right? So who cannot be evicted from a condo conversion? Because you can't just evict people because you want to convert it to condos. Otherwise, you got to wait 3 years and 2 months. Well, if the tenants there meet all these following criteria, they can remain as tenants for 40 more years and cannot be evicted. Tenants who are age 62 and older, or have or disabled, if they lived there for at least 2 years before the conversion began, and their income is no more than 3 times their county per capita average, or in any case, no more than $50,000 a year. If they meet all those requirements, they could remain as tenants for the next 40 years, and you can't kick them out just so that you could sell the units. Okay. These are those people that you see on those Law and Order episodes that are murdered. Right? You ever see one of those Law and Order episodes where this person was renting still for $600 a month? Aren't these units going for tens of thousands of dollars for rent a month? Yeah, but this person was they were a holdover before they converted the building, and they're still allowed to be there as renters. And they're like, oh, so we got to look into the owners. Maybe they're the ones that tried to kill them. But yeah, those are the criteria for who cannot be evicted from a condo conversion. All right. So let's highlight that now on page 127. Who cannot be evicted from condo conversions? That's right here in the highlights.
So can they move them out temporarily? Like, let's say they find them another suitable living situation. Is that
upgrade what are you talking about? To upgrade the unit?
Yeah.
Yeah, to upgrade the unit's fine, as long as they come back into a new upgraded unit.
Okay.
But they're still going to be there as renters.
Okay.
Is it legal for them to buy them out?
I would say talk to an attorney on that. And for you as a real estate agent, I'm going to tell you, do not get involved.
Yeah, we don't give the advice, but I'm just asking.
Well, no. I'm saying for you as a real estate agent, do not get involved in that, because there's something called cash for keys that sometimes when banks were foreclosing on people, and there were renters in the building, the banks are trying to sell. It's harder to sell with the renters in there sometimes when the renters don't cooperate with showings and such. So when banks foreclose on people and they get a property that has renters, they were having real estate agents approach the renters. They were paying real estate agents to approach renters and offer them money to get the hell out. Similar to what you're saying, right?
Yep.
So the Real Estate Commission put out a warning. It's still on their website today. And it basically says you want to lose your license, you could do that, because this is intimidation, renters, intimidation of those renters because they know the property got foreclosed on. Now you're offering them money to get out. It's kind of like you're strong arming them a little bit. They're feeling like pressure that the landlord really wants them out, and something's going to happen if they don't go voluntarily. And hey, they're offering me money to go now. So, they feel kind of helpless, but it is intimidation of those renters. So, real estate agents, I never did it, but I know of agents that did do that. They said the real estate commission put out a warning to those agents, said don't get involved in that. We're warning you right now, don't do it.
Yeah, no, the only reason I ask is because my father-in-law, he lived in Manhattan, and the same thing with his building, and then they paid him. They paid him out to leave.
But he didn't have to leave. He could have stayed there.
Correct. Yeah.
They have to honor the lease. So basically, even after foreclosure,
even
if
after
you have a
like,
tenant in there that has a lease, the lender has to, whoever got the property at foreclosure, they have to honor that lease. They can't kick you out.
Yeah, I mean, no, he was living there for years, and the only reason that he left is because he moved to Jersey with us. Closer to here. So that was the only reason that he
So he
left.
took the money and ran. Yeah, I got you.
Yeah.
Yeah, I got you. All right. All right, so we're also highlighting, make sure you get that highlight there too, that remember, condo owners receive a deed and therefore own real estate, whereas co-op owners receive shares of stock and a proprietary lease, both of which are personal property and therefore technically do not own real estate. All right. So a townhouse is multi-level attached housing that shares common party walls separating the units side to side. Townhouses don't have units above each other. They have them side by side. It's multi-level. Each unit is multi-level. All right. So townhouses can be condominiums with an HOA, the homeowners association, and rules to follow. Or they could be fee simple ownership without an HOA. They're not part of a condo complex. It's impossible to tell then by simply looking at the structure if it is a condo or fee simple ownership type of townhouse. Townhouse is simply an architectural style. It's attached multi-level housing. So let's highlight the term townhouse is used to describe an architectural style which buildings share a common party wall. Townhouse developments can be condos or they can be owned in fee simple. So you will get some kind of question on exam knowing the difference between condos and townhouses, because sometimes, often, people get these confused. And as a real estate agent, you should not, because a condo is a form of ownership. Townhouse is an architectural style. Townhouses can be condos, but they don't need to be. See, we get people sometimes, they call the office and they're looking for a townhouse, but they don't want any of those condos. They don't want to have to worry about people living upstairs from them and, walking around banging on the floor, or they don't want to worry about snow removal or cutting the grass. Okay, wait. So what you're describing is you want a townhouse, because townhouse, you're not going to, what they're describing is they don't want the apartment style condominiums. But they do want a condominium because they're saying that they don't want to worry about cutting the grass or snow removal. Okay, so that's a townhouse that is a condo is what they're looking for. See, sometimes when people call up, they think they know what they're explaining, what they want, and they really don't know what it is, how to explain it properly. We're not there to correct them, but we are there to try to decipher and figure out what the hell it is they're talking about that they want, right? So, condo is a form of ownership. It has an HOA in charge of maintenance and common area elements, usually on the exterior, and they have their own rules that each owner must follow, those CCNRs that are set up in the bylaws. Townhouse is an architectural style. It's not a form of ownership. It's multi-level attached housing that shares a common party wall. Party wall is a wall that separates two units, right? And the townhouse could be fee simple ownership, or it can be condos. Often they are condos, where the owner doesn't have to worry about cutting the grass or removing the snow, or the maintenance of the siding or the roofs, etc., or the gutters getting clogged. The homeowners association would clear them out. They could be fee simple ownership without a homeowners association too. Now they say generally it's impossible to tell by looking at a unit if the townhouse is a condo or fee simple ownership. But I'm going to tell you, more times than not, you could tell. Here's a picture of some townhouses that are about 100 years old from my town. This is on St. George Avenue in Linden. You got maybe about 10 units here in this complex. It's about 100 years old. But take a look at the exterior of it for a second. Now, sometimes townhouses, you can have complexes or condo units where they alternate color patterns. But here it's a little bit more than that. It's not just alternating color patterns. It's also different types of roof. It's also different types of stairs and different types of railings on stairs. If this is a condo, condominiums believe in uniformity because uniformity maintains value better. Everything is going to be the same. And if it's going to be an alternating color pattern, it's going to be a consistent alternating color pattern, maybe something that matches. Not like this. You got a beige next to this yellow, next to a green snot color, next to another beige, different types of roof. One looks like it's got a vinyl siding as the roof. The other one's got shingles. Here's another one. Here's a look of the whole complex. Look at this unit down the end. It's got bushes that are overgrowing. This is falling apart. There's the driveway on the side that goes to the back for the complex. But you could see some units are maintained. Some are overgrown with the bushes. They're not maintained as well. You could tell that these townhouses are fee simple ownership. There's no condo. These are not condos. And I know that they aren't because I know somebody that lives in one of those units there. All right. So next up, time sharing. You guys ever hear of a timeshare? Timeshare is a form of ownership of real estate. So let's highlight time sharing, and right next to that is a form of shared ownership. It is ownership, though.
The one to stay away from.
Yeah, probably one of the worst purchases you could ever make. And I'm going to show you a 3-part video series in the coming slides that's going to explain to you why. All right. What do they say here? Let me see. The buyer of a timeshare receives a fraction of the year's ownership. Yeah, you got 52 weeks in a year. You may have 52 different owners, each owning 1 week out of the year of a condo unit. Instead of going and getting a hotel every time you go on vacation, you could have a timeshare where you share the ownership with other owners and you own it for 1 week out of the year. Let me see. They say the buyer of a timeshare receives a fraction of the year's ownership of the use of the property, which might be a hotel, townhouse, single-family detached home, campground, or even a motel, or high-rise condos, whatever. In some cases, only a right to use is purchased. In others, the owner has a true fee simple interest in the real estate. Although the concept is most popular in resort destination areas like the Caribbean, Colorado, Vermont, Florida, Las Vegas, Nevada. They got them all over the place. Long Island, Pocono. It has been used in Long Island and the Poconos and other nearby resort areas. An owner can exchange, sell, or rent a time slot subject only to the restrictions in the prospectus of the organization administering the property. It's also not useful for an interval to be for a specific week or each year. The New Jersey timeshare law applies to timeshares sold in New Jersey as well as those located outside of New Jersey but sold in the state. The act requires that certain disclosures be made when certain types of out-of-state properties, such as subdivided land sales, condominiums, and common interest ownership properties, are offered for sale in New Jersey. Highlight: a timeshare buyer has the right to cancel a timeshare up to 7 calendar days or up to 7 days after signing the contract or after receipt of the public offering statement, whichever is later. The buyer may cancel by certified mail or in person, whereupon the seller must refund the payments within 30 days. That's for new construction only. I'm going to write that there on the side there. Make sure you write for new construction. These are the new initial timeshare sale purchase. The developer or timeshare salesperson is required to provide an honest, not false information to make any predictions of increases in value or misrepresentations of how a buyer may use or exchange the timeshare. New Jersey Real Estate Timeshare Act does not apply to 10 or fewer timeshare interests, investments of less than $3,000 or to resales. That's only applies to new construction, in other words, the initial sale. So the Bureau of Subdivided Land Sales Control, that's a part of the New Jersey Real Estate Commission. They're dedicated to going out and investigating the properties and checking all their paperwork, inspecting the properties, make sure they actually exist and not selling you swampland in Florida or anything like that, you know. They enforce the registration and anti-fraud provisions of the New Jersey Real Estate Sales Full Disclosure Act. So, timesharing is a form of ownership. It's a form of real estate ownership for a short period of time each year. You own it for 1 week, 2 weeks, or 1 month. I've even seen timeshare sales of cabins on cruise ships. Maybe for one specific week each year. The penalties for licensees that violate timeshare laws is a minimum $250 fine with a maximum $50,000 per offense for out-of-state subdivided land and timeshare sales, which fall under 4515-16.50 and 4515-16.79 in the real estate law. Okay, so here, let's start this series here. This guy, he actually used to be involved working for a timeshare sales company. And then he started his own company on helping people get out of timeshares.
If you bought a timeshare for your family, by now you've learned the ugly truth. Timeshares are the only thing that you can buy that you don't know how much it's going to cost or when it's going to end. It's like giving them a blank check for annual maintenance and assessment fees. Sounds crazy, right? The ugly truth is that this never ends. Hello, I'm Chuck McDowell, and 10 years ago, I founded Wesley Financial Group with one goal in mind, helping good folks just like you cancel their timeshare contract. And what that means for you and your family, no more mortgage payments, no more maintenance fee surprises, and no more timeshare. So call today.
All right.
If you bought
now his company created this 3-part mini-series on timeshares explaining what they are. So I'll I'll shut off my camera and I'll minimize all of yours so that we can get some optimal video performance here as we play and learn about timeshares.
We have a consumer warning to tell you about this afternoon for anyone who's trying to sell a timeshare.
Probably heard horror stories of folks going into a timeshare sales pitch and being stuck there for hours.
The maintenance fees were going up 12.5% every single year.
This is the Great American Timeshare Scam. Like most bad things, timeshare started out with really good intentions. But greed, deception, and manipulation has distorted this once creative tool that helped families vacation and turned it into a lifetime of debt for millions of families. In the 60s and 70s, timeshare was a brand new, innovative way to fund property development. And for a while, the system worked. Resorts popped up everywhere, with families owning fixed-week timeshares at a reasonable cost. So what changed? Timeshare companies became obsessed with the bottom line. Profits, money, commissions. Oh my. And now, this steal of a deal, own your vacation, you just bought a house scheme is bribing people to attend sales meetings and deceiving families into a loan that can never be repaid. Thanks for watching. This was actually just part 1 of a 3-part series on the most deceptive practices within the timeshare industry. If you're interested in learning more, watch part 2, the dark psychology of the timeshare sales meeting. In that video, we go over the manipulative and dishonest tools the timeshare salesmen use to make the sale, to make you buy. Spoiler alert, it's not a sales pitch, it's a show.
Are you a licensed real estate agent to be involved in timeshares?
No.
Yes, you need to have a real estate license. It is selling real estate. And when you own a timeshare, you do own real estate. You only own it for maybe 1 week out of the year, but it definitely is ownership of real estate. So yes, you do need to have a real estate license, and it is highly regulated. That's why I was showing you the fines, a minimum of $250 to a maximum of $50,000 per offense, depending on what it is in the by the Real Estate Commission. Okay, let's take a look at part 2 here, the dark psychology involved in timeshare sales.
You own your house. Why wouldn't you own your vacation? Deals like this come once in a lifetime, and you won't have access to it once you step out of this meeting.
If you've ever sat through a timeshare presentation, you've likely heard this phrase or something like it before. This technique is called the exploding offer, or what is more commonly known as FOMO. And unfortunately, it's not the only technique they're using on you to make the deal. This is the dark psychology of the timeshare sales meeting. So how do people find themselves in awful timeshare situations? Simple. Timeshare salesmen understand humanity's dark psychology. For example,
if you don't do this now, this deal may run out and be gone forever.
What does your brain instinctively want to do now that you've heard this?
Do it before it's too late.
This tactic is known as the scarcity effect. Scarcity pushes people to make impulsive decisions like buying up all the toilet paper during a global pandemic because...
What if we run out of all the toilet paper?
Right. Very rational. We're not going to go too far down that rabbit hole, but generally a feeling of regret follows impulse buys. Stop me if you know it. Buyer's remorse. Another example is the law of reciprocity, where people feel obligated to stay for the sales meeting because they were given free tickets to an event or a free dinner. This is why they... Watch the glass. This is why they bribe people to come to the sales presentation, because it makes people feel like they should give back their time in exchange for these gifts. And these are just a few examples of the dark psychology timeshare salesmen use. They are masters of persuasion. This is why it's so important to be aware of the psychological influences that affect decision making. That way, you never find yourself in a timeshare presentation to begin with.
Ready for vacations for life?
Keep on walking, pal. Thanks for watching, and stay tuned. You just finished part 2 of our 3-part series on the deceptive practices to look out for in the timeshare industry. The next video is the timeshare contract. In that video, we go over why the timeshare companies will pressure you into that first sale, because once they've got you, they're not going to let you go, at least not without a fight.
Oh, jump. Now it's time to take a look at Timeshares 3.
You own your house.
Timeshare's an investment. You'll be able to rent it out. You'll be able to travel anywhere you want for life. This is the timeshare contract. I'm gonna save you the heartache and explain why the timeshare companies try so hard to sell you timeshare. Because the first sale is just the beginning of the ultimate con that's about to destroy your finances. Let's start with the low-hanging fruit. If they can convince you to buy a timeshare, they're guaranteed consistent yearly income without having to give you anything but imaginary points. What a deal for the timeshare company, right? Free maintenance paid for by you for their property that they actually own. They're called maintenance fees, and they go up every single year. A big fat commission because timeshare barely costs the company anything. Seriously, sometimes that salesperson is getting over 30%. And get this, once they've got you, it's nearly impossible to get out. If you try to cancel, they'll tell you they can't do anything. You signed a contract. They may even tell you to sell it yourself. They definitely won't buy it back. They don't want it, and they know it has no value. But if you try to sell it, it turns out no one else actually wants to buy it either. Spoiler alert, there is no market for timeshare resales. None, zero, zilch, nil market for it. Look at this eBay listing for a timeshare. For $1. We've even seen people offer gift cards to take their timeshare. No, I'm good, man.
But it's an investment.
Get out of here! What's crazier is that these timeshares still won't sell, so families are stuck in the timeshare scam, paying all their outrageous fees. And then, when they finally had enough, they're out more money for another service to help them get rid of it. Now, hypothetically, hang with me here, let's say you actually did get that timeshare sold. This means someone else now has your timeshare, which is perfect, right? You no longer have to deal with this financial burden. But there could be a catch, and we've seen this happen over and over. If the person who bought your timeshare stops paying and the timeshare company comes calling, guess who could be on the hook for all of that debt? Yep, the original owner of the timeshare. Oh, shh. And I say this to really show you how hard getting out of a timeshare is. There are plenty of other stories and examples of this kind of unfortunate situation, but I think you get the sad point. Oftentimes, once an owner has tried a couple different avenues to get out, they begin to lose hope. This is what the timeshare companies count on. They want you to sit down, shut up, and pay them your money without actually getting anything in return. They seem more like a mafia than a reputable business.
I'm going to sell you a timeshare you can't refuse.
But thankfully, you don't have to be hopeless. It seems like one of the only ways you can actually cancel your timeshare and all its related debt and fees is through a timeshare exit company. It isn't easy, and it can take up to 3 years, but it is possible. The only caveat per se is that it needs to be a reputable company. There are a few good ones out there, but as these timeshare exit companies have gotten bigger, the timeshare companies have actually started suing them into oblivion. We know this for a fact because they sued us too, but we beat them in federal court for the right to help people like you get relief from the burden of the never-ending lies and fees. This video series only scratches the surface on the most deceptive practices within the timeshare industry. If you want more videos like this, hit that like button. And if you have experienced any of these tactics yourself, tell your story below. It helps people understand that they are not alone, and the situation they found themselves in is nothing to be embarrassed about. Also, if you haven't seen the other videos in this series yet, make sure to check out The Great American Timeshare Scam and The Dark Psychology of the Timeshare Meeting. What you discover may shock you.
Thought that was educational.
Timeshare.
I learned a little bit about timeshares and how they work there. So when you own a timeshare, do you own real estate? Yes, you do. It's a very short period of time, perhaps maybe 1 week out of a year, but you still own real estate. So which one of these is not a form of real estate ownership? Fee simple, my mind just went blank. Which one of these is not a form of ownership? Fee simple, timeshare, co-op, or condo?
Co-op.
Co-op. That is correct. So let's go over some architectural styles. You guys should familiarize yourself with them. I'm trying to work on putting together a guide for everybody for this. But there are many different types of architectural styles out there. You guys should be familiar with some of the basics at least, because when we do get listings, we have to put them in the MLS and we have to select so that we don't corrupt that database with wrong information. You should know and be able to identify an architectural style of a property so you could enter the proper information into the MLS when we get listings. So here's some of the common ones we get here in New Jersey. We have Cape Cods, colonials, Victorians, ranches, raised ranches, bungalows, split levels, Tudors, contemporary, bi-levels. That's bi is two, one unit above the other. Townhouses, duplex, that's a two-family house side by side. Over under, that's a two-family house, one unit above the other. Art Deco, Craftsman, Salt Box, Dutch Colonial, Federal, Georgian, Monterey, Gothic, Pueblo, Greek, Queen Anne, apartment, high rise. These are all common ones that we could find here in New Jersey. All right. So here's also a guide from Realtor.com. They put together a guide for us. It's not that great, but it's better than nothing. It's a basic explanation of some standard like Cape Cods. Like I live in a Cape Cod. My house doesn't look like this, okay? I have an attached garage to mine. My roof pitches front, It's a little bit different, but it does have living space on the first floor, a kitchen, dining room, living room, and 2 bedrooms. And I have 2 bedrooms on the second floor. And then it has a full basement and an attached garage. So there can be some differences, and there's different styles. You have a small, medium, and large type Cape Cod houses too, which the layout then completely changes on the interior. Bungalows, colonials, contemporary. So you got some guidance here about some of the basics, and if you click on these, it gives you a basic explanation of the differences. And if you want to see the structural elements, you could click on this. Also see structural elements, where now you can see like different types of arches above windows and what they're called, and and a little explanation for them, where they came from. Columns, dormers, the windows stick out the roofs there, or moldings, different molding styles. Roofs. This is a cross gabled roof. This is a front gabled roof. See, I got a cross gabled roof on my house. Then we got the gambrel style, which looks like a barn, that barn style. Hipped, mansard, pavilion, yada yada. And types of window casements. We have bay windows, a bow window, a box bay window, casement window, gives you that historical multi-window, small little window look. Double hung, aureole, paired, Palladian, ribbon. All right, just some basics about the different architectural styles. But if you have not yet subscribed to our Facebook page, facebook.com/Career Path Academy, I already started working on this, and I got a little bit left to go, but I'll be publishing it shortly so you guys can get a better architectural style guide than what they're even showing here. One thing I can't find online is a decent architectural style guide for real estate agents, and it is important to have or to know. So that's the end of this chapter. chapter 7. So let's do the key terms to review on page 129 and 130. There are 2 key terms to review in this chapter. We'll start off with key terms to review number 1. Are you ready?
We are ready.
All right, let's do this. Ownership. What's another word for ownership?
Title.
13 is A, title.
Wait.
Yeah.
13.
Wait.
Oh, hold on. Okay, so 13. Oh, I see. So you're starting the right. Okay, got it.
Okay, so let me start off. Page 129. We got 2 key terms to review in this particular chapter. Some chapters have 1, some have 4 or 5. They vary in how many key terms to review they have. The way it works is like this. I'll read out the answer on the right-hand side of the page. You're going to shout out what you think the corresponding phrase that matches up to it on the left-hand side of the page.
Okay.
There's no penalties for wrong answers, so shout them out as you got them. Are you ready?
Ready.
Let's do this. So we did the first one. Ownership is title. 13 is A. Default form of ownership for those who are unmarried and not in a civil union.
Tenancy in common. Tick.
11 is B, the tenancy in common. Person named in a will to inherit real estate. What do we call the person who is named in a will to inherit real estate?
Devisee.
Devisee. 2 is C. A group with each partner that's completely liable.
Joint tenancy.
General partnership.
General partnership, when we're talking about the business owners, right? That's the group with each partner that's completely liable, is the general partner. 3 is D. Non-married person with the right of survivorship. If you're not married and you have the right of survivorship,
I will say joint tenancy.
Joint tenancy is correct. 4 is E. A business owned by one person or entity.
Sole proprietorship.
A sole proprietorship. 9 is F. Co-owners join together to carry on a business. What do we call it when you got more than one owner?
A joint tenancy?
Of a business.
Limited partnership.
It's a tenancy
partnership.
Simply a partnership. There's not enough info to know what kind of partnership. So it's simply a partnership. 7 is G. Court-ordered sale and division of a property.
Partition.
6 is H. It's a partition. Legal entity considered to be an artificial person.
Legal entity considered to
artificial person.
For legal protections and taxation purposes.
Gotta be
corporation.
It is. 1 is I, corporation. Process by which co-owner automatically receives share of co-owner who dies. What do we call the process? 8 is J, the right of survivorship. That is correct. The right of survivorship. 8 is J. Special ownership by married couples. Who also have the right of survivorship.
It must be tenancy by entirety.
10 is K, tenancy by the entirety. Real estate ownership by only one. What do we call ownership by only one person or entity?
Limited partnership.
No, sole proprietor. No.
Tenancy in severalty.
Tenancy in severalty. Remember, the root word is severed. Your interests are severed from all others. And it could be an individual person or it could be a business that owns on their own. 12 is L, tenancy in severalty. Group with only general partner fully liable. And there may be others that have no liability.
What is it?
Limited partnership.
It is a limited partnership. 5 is M. All right. Turn the page. We got another key terms to review on page 130. Co-op owners' right to a specific apartment. What gives them the right to live in that specific apartment?
Timeshare?
Horizontal Properties Act?
No.
Oh, no, the lease.
What kind of lease?
Proprietary lease.
A proprietary lease. 8 is A. A group elected to manage a cooperative.
Homeowners
Board.
Association.
Oh,
No.
Board of directors.
The board of directors. 1 is B. Remember, cooperative is managed by a it's owned by a corporation. And who makes all the decisions in a corporation? The board of directors. So 1 is B. Architectural term.
Townhouse.
11 is C. Stairwells, roofs, etc. owned by all. These are all considered basketball courts, swimming pools,
Common
tennis
element.
courts. These are common area elements. Correct. 2 is D. Apartment whose buyer receives a proprietary lease and stock in the corporation.
Co-op.
A cooperative, or co-op for short. 5 is E. Fee simple ownership of a living unit. Fee simple ownership of a living unit.
Condo? No.
Yes,
timeshare?
it is. No, it is. You got it right the first time. It's condominium. 3 is F.
Oh, condominium.
All owners in one condominium complex. All of the owners in one condominium complex. They're all going to be part of this.
The homeowner
Association.
6 is G, the homeowners association to which all will belong, right? 6 is G. Apartment house changed to condos. What do we call that when you're changing an apartment house or multifamily house to condos? It is a what? Conversion. 4 is H. Money set aside for future repairs.
Reserves.
9 is I, reserves. Ownership for part of a year.
Robbery. Oh, sorry, timeshare.
Timeshares. 10 is J. Regulates the creation of condominiums.
Horizontal Properties Act.
7 is K, the Horizontal Properties Act. And that concludes chapter 7. So,
great.